But why don't we get going? My name is John Delaney, and I'm the Commission's designated presiding officer for this hearing. Today is January 23rd, 2024, and it's approximately 9:03 a.m., and this is the date and time that's scheduled for the hearing on the settlement stipulation between Dominion Energy Utah and the Utah Department of Public Utilities in Docket 23-057-13. You guys hear that?
Yeah, I think someone on the phone is not muted.
Whoever's on the phone, could you please mute? Or everybody on the phone, please mute. Does it look like it happened? Okay.
Thank you.
Thank you. Okay, why don't we, we're all at the right place, correct? Okay, let's start with appearances for Dominion.
Thank you. My name is Jennifer Clark. I am counsel for Dominion Energy. I have with me Austin Summers, and he will be speaking on behalf of the company today. He will be the only witness we will offer. However, we have brought with us Will Radford, Justin Withers, and Mayor Marty Larson is on the phone, should the commission have any questions for them.
Thank you. And for the division.
Good morning, Patricia E. Schmid with the Utah Attorney General's Office for the division. The division's witness today is Tyler McIntosh.
Okay, good morning, everybody. Okay, was that the preliminary matter you had to raise? You said you had one preliminary matter?
No, I do have one preliminary matter.
Please.
Thank you. Paragraph 16 of the settlement stipulation provides that the parties agree that all pre-filed testimony and exhibits can be admitted, and I conferred with Ms. Schmidt prior to the hearing, and I would move for the admission of all those exhibits.
Would you care to join that motion?
The division would like to join that motion. Thank you.
Okay, so there's no objections. The motion is granted.
Thank you.
The stuff is admitted.
Thank you.
Any other preliminary matters?
No.
Ms. Schmidt?
No.
Okay. I have one, which we might get to, but, okay, so I understand from the settlement stipulation document that the Office of Consumer Services is not a party to this docket. Well, that's how it's stated. But they have reviewed the settlement stipulation, and it has authorized the division and DEU to represent that it, the OCS, is not opposed to the terms agreed upon in that document. Is that still accurate?
To my knowledge, yes.
Okay.
Yes.
Okay. And will your respective witnesses will offer testimony on that specific point?
No, but Mr. Summers certainly can.
I think it would be helpful to have it on the record.
Okay.
If you all don't, I'll try to remember to ask you specifically. All right, that's the only preliminary matter I had. Why don't we go ahead, Ms. Clark, call your first witness.
Thank you. The company calls Austin Summers.
Good morning, Mr. Summers.
Good morning.
You're used to coming up to the stand.
We are here again.
Yes, we are. Do you swear to tell the truth?
I do.
Okay,
Yes.
please proceed, Mrs. Clark. Ms. Clark.
Thank you. Mr. Summers, please state your name and business address for the record.
My name is Austin Summers. My business address is 333 South State Street, Salt Lake City, Utah.
And what position do you hold with the company?
I'm a manager of rates and regulation.
Mr. Summers, are you the same Austin Summers who submitted pre-filed direct testimony in this matter?
Yes.
And did you participate in the negotiation and drafting of the settlement stipulation that is before the commission today?
Yes, I did.
And the settlement stipulation, Mr. Summers, makes representations about the Office of Consumer Services. Can you confirm that the Office of Consumer Services reviewed the settlement stipulation and authorized the company to represent that it does not oppose the terms contained therein?
Yes.
Can you summarize for the commission the settlement stipulation that is
Yes.
before them today? Thanks.
Good morning again, Mr. Delaney. Thank you for your time today. And before I begin, I just wanted to thank the staff at the Division of Public Utilities for its feedback in making the settlement happen. In this docket, Dominion Energy seeks commission approval to expand to the rural community of Genola. Though this would be new infrastructure in a new rural community, the resource decision is nothing more than a continuation of the program that was approved in Eureka, Goshen, and Green River dockets. The application and accompanying testimony provided all of the evidence required to support approval of the resource decision. In my pre-filed direct testimony, I addressed the evidentiary requirements for the resource decision, discussed how and why the company chose Genola as the next expansion location, explained how many customers are expected to participate, how costs would be recovered, and provided other relevant financial and operational information. Mr. Radford's testimony explains the scope of the project, the construction schedule, the cost of the project, and the geographic results of the community's interest in natural gas. Mr. Withers' testimony discussed the process of converting appliances to natural gas, the disposal of propane equipment, and the safety benefits of being a Dominion Energy customer. Finally, Mayor Larson discussed community growth in Genola, the benefits natural gas would bring to his community, and explained his support of this project. Taken together, the evidence provided shows that the resource decision is just and reasonable in result, and that approval of the application is in the public interest. The settlement stipulation largely accepts the company's proposal as filed. There are a few additional provisions, so I'll draw your attention to paragraphs 6 through 10 of the settlement stipulation, and I'll just walk through those briefly. Paragraph 6 states that Dominion Energy should be authorized to construct the facilities proposed in the application to serve the community of Genola. Paragraph 7 explains that the costs of the expansion will be collected through the Rural Expansion Rate Adjustment Tracker that is contained in Section 9.02 of the tariff. Paragraph 8 provides that the company will file a copy of the permits and other similar items with the Commission once they are finalized and executed. Paragraph 9 states that if the costs of the resource decision exceed the estimates provided in the testimony of Mr. Radford, the company will seek Commission approval of the excess costs prior to including those costs in the tracker. Approval of any increase will be subject to the statutory spending caps that are discussed in my direct testimony. And then finally, paragraph 10 states that the company will work with Genola to ensure that appliance inspections by the city are occurring before a meter is set. Based on the evidence in the record and the stipulation of the parties in this docket, the company requests approval of the settlement stipulation. The company stands ready to start construction upon Commission approval. That ends my summary.
Mr. Summers is available for cross-examination or questions from the hearing officer.
Thank you very much. Ms. Schmidt, any questions from the division?
No questions.
Okay, thank you. Mr. Summers, I do have two questions.
Okay.
Thank you for running through those paragraphs you just ran through. I do have two questions on two of those paragraphs.
Okay.
Paragraph 8 addresses the notion of the permit filing.
Yes.
So this issue came up in an earlier docket about the timing of the filing. That is, my recollection from the earlier docket was that DEU's preference was to provide them in batches instead of piecemeal as they were provided. I see now here, though, there's language that says executed and finalized. So can you confirm that what that means is DEU will provide these on a rolling basis, or is it the intention of the parties to do otherwise?
In the past, what we've done is there are permits coming through constantly. Mm-hmm. And so in Eureka, there weren't a lot of permits, and so we filed those all in one batch. In Goshen and Alberta, I don't think that there was anything in a settlement that said to file them. So in Green River, when we filed them, we waited until the end because, again, they were just coming through sporadically through, and then we filed them all in one batch and kept them all in one package. Mm-hmm. If the commission preferred to see them more frequently as they're coming in, I don't think that the company would be proposed to filing those in smaller batches as they're coming in. I know that the Green River docket had a lot more permits, just because of the, I don't know, the sophistication of the project and the railroad crossings that were involved and the washes that had to be crossed, and so there were a lot more permits in that one. So I don't know that maybe Mr. Radford would be able to speak to how many permits would be anticipated, but I think the answer to that is if the commission would prefer to see those in smaller batches, we would be happy to do that.
Well, the genesis of my concern is I think it was the Green River docket. There was actually a dispute about this issue on the increase on the voluntary resource decision. And there seemed to be a misunderstanding about this, what I think is not a gigantic issue. There was an expectation on one side that you guys should have been providing these documents as they came in, and DEU's response was, no, we actually are kind of putting them all together and we'll give you in that tranche.
Yeah.
So there was a disagreement that seemed to me that if we can have an understanding now, we won't have that disagreement here, but it does presuppose that there will be a lot of permits, and maybe that predicate doesn't exist here.
Yeah, and I'm remembering too, when in the Green River docket, we had assembled a lot of those permits when that comment was made, and they were asking for those, but if we had filed them with the comments at that time, it wouldn't have given the division more than a week or two, if I remember right, to actually respond to analyze those permits and to actually get them. So if we had included them, I believe it was in our reply comments, they would have had to have looked at those. I don't know, I guess my understanding is that they would have had to have looked at those more quickly, but by waiting and including them just at the end of the project, it gave them more time to kind of sift through all of those permits on their own timeline.
Okay, so thank you for everything you've told me. My question was, is there an understanding about whether it's going to be piecemeal or in tranche? And I think what your answer is, you're not sure as you sit here.
Yeah, we have not come to an understanding with the Division of Public Utilities about how they would like to see those.
That's fine.
I would make the commitment that if they want to have that conversation, we would be happy to have that conversation with them.
Okay, thank you. And I'll ask the same question of the DPU witness.
Thank you.
And maybe you can get some clarity here today, and if not, I appreciate the offer to do it after.
Okay.
Thank you. So the next question is with respect to paragraph 10. The parties agree for purposes of the settlement that the company will work with Genola. I wonder if you can give me a little more color about what work with means. I understand it's tied to the safety issue and that it's tied to a meter set, but I'm just not quite sure what work with means. Can you give me a little context?
Yeah, I'd be happy to. When we first met with Eureka and we were meeting with the Division of Public Utilities, one of the big concerns was that there might be a homeowner who decides to run their own gas piping and do their own work, and there was concern that if it wasn't done by a professional, there might be safety issues. And that's a fair concern. So as part of the Eureka process, it's actually Mr. Withers is the region manager for that area, and he worked to have one of our employees that would go out and look at their piping if there was any questions about how to set up their appliances, those kinds of things, before a city inspector went out to make the official confirmation that everything was set up. That was designed to keep us in the loop with the city, and so that we knew that everything was going in correctly. City had confidence that everything was going in correctly, and then that was just verified by a city inspector. With regard to a meter set, never thought this experience would come in handy, but I used to work in the meter set department, and what would happen is the city would notify Dominion that everything was in line, that it held a pressure test, that everything was ready to go before we would go out and set a meter. And so we have kind of that second layer of confidence that everything is installed safely before we will put a meter on the house.
Okay. So I'm sorry if I missed something, but I think everything you explained to me before the meter set, you were speaking in terms of Eureka. So did you mean to say, and we will follow that
And
same?
we will follow that same procedure. We have followed that same procedure in Goshen and Alberta. We've followed that same procedure in Green River, and we will do the same thing in Genola.
Genola, okay. Goshen and Genola, G and G.
I know, you have no idea how many times.
I can imagine. Okay, and there was also some testimony about the disposal of the appliances. Is that part of the working with Genola concept here?
The original disposal, and I don't know if it was disposal of appliances necessarily, but the big concern was the disposal of the tanks,
Okay.
of the propane tanks. There was a concern that propane tanks would be left sitting in yards and that they'd still have propane in them, and that could be a danger. And so now I'm going to go back and talk about Eureka again, but I will bring it back to Genola.
Thank you.
Because that is, we learned a lot of lessons in Eureka. And I think the big concern that was brought up there was by the propane companies. But as we've had some experience with those, a lot of those tanks are leased. And so when the customer is done using the propane tank, the propane operator will come in and they will take the tank with them. If the tank is owned, that is on the customer. In the case of Eureka, I know that the mayor had said, if you want to put them in this lot, you can put them in this lot, but a lot of them were leased, and so it wasn't as big of an issue as what the propane group in that docket had stated. The other thing that I've noticed as I've talked with the people who are setting up these meters and getting these new customers ready is that customers will coordinate with us as their propane is getting empty. So they will use up as much propane. They've already paid for it, so they'll use up as much propane as they can, and then as their tank is emptying, that's when they'll connect to natural gas. So I don't think that the safety issue has been as much of an issue as what was brought up in that original Eureka case. We do continue to work with customers as our employees are out there and talking with them. Before a city inspector, we will be having those same conversations about how to make sure your propane tank is safe and kind of coordinating with them. So we're doing that in every area that we go to make sure that everything is as safe as it can.
Okay, thank you very much. That was
welcome.
very helpful. That's all I have.
Okay.
Thank you very much.
Thank you.
Okay, Ms. Schmidt, would you like to call your first witness?
Yes, the division would like to call its first and only witness, Tyler McIntosh.
Thank you. Good morning, Mr. McIntosh.
Morning.
Oh, your microphone's working, good.
Yeah,
Do you swear to tell the truth?
I do.
Great, thanks. Please proceed.
Thank you. Mr. McIntosh, could you please state and spell your full name for the record?
My name is Tyler McIntosh. That's TYLER MCINTOSH.
Is the C a capital letter C or a
So
small c?
so the C is a small c and the I is a capital I.
Thank you.
Thanks for clarifying.
Could you please state your employer, your job title, and your business address?
Yep, I work with the Division of Public Utilities. I'm a utility analyst, and my address is 160 East, 300 South, Salt Lake City, Utah.
Because we haven't heard from you as often as we have heard from some of the division's other witnesses, could you please briefly describe your educational experience for the record?
I can. I received a dual bachelor's degree from the University of Utah in finance and information systems. And yeah,
In connection with your employment at the division, have you been involved in this docket on behalf of the division?
I have.
Did that involvement include reviewing the testimonies, the exhibits, data responses, having discussions with the company and others? Question mark.
Yes, all of the above.
Thank you.
Uh-huh.
Were you involved in the preparation and filing of your direct testimony?
I was.
Were you involved in the discussions, negotiations, and the resulting settlement in this docket?
I was.
Is it your understanding that while the office did not file testimony in this docket, it has represented that it does not oppose the stipulation?
That is correct.
Do you have a summary to present today?
I do.
Please proceed.
Okay. In docket 23-05713, Dominion Energy, and I'll refer to them as DEU or the company, asks for the commission approval to extend service to Genola, Utah. The company and DEU now seek commission approval of the filed settlement stipulation addressing extending service to Genola. Genola is a city in Utah County with a population of approximately 1,593 residents and covers approximately 6.2 square miles. The Genola expansion has the potential to serve approximately 507 customers and will not require new high-pressure pipe or additional regulator stations. In 2018, the Utah legislature passed House Bill 422, which provided an opportunity for rural communities to obtain natural gas services, which would be funded by the rest of the company's customer base. On December 1st, 2023, the division submitted direct testimony in the docket. The division and the company were active parties to this docket. After the division filed its direct testimony, the company and the division engaged in arm's-length settlement discussions and negotiations and resulted in the settlement stipulation before you. Of particular importance to the division are the settlement stipulation provisions addressing that the infrastructure expansion meets the requirement for Section 5417-401 and is just and reasonable and in the public interest. Of particular importance to the division are the following provisions in the stipulation. In paragraph 8, it states that Dominion Energy will file all necessary permits for the Genola expansion when they are finalized and executed. Paragraph 9 prevents excess project spending without additional approval from the Commission. And paragraph 10 affirms that the company will work with the city of Genola for safe conversion to natural gas services. A Commission statute 5471 states, and I quote in part, "Informal resolution by agreement of the parties of matters before the Commission is encouraged for various reasons, such as minimizing the time and expense required to resolve disputes. To approve a settlement, the Commission must find that the settlement proposal is just and reasonable in result, and that the recorded evidence supports a finding that the settlement proposal is just and reasonable in result. The division has analyzed the filings in this docket and engaged in meaningful and robust settlement discussions leading to the filing of the settlement in this case. It is the testimony of the division that the settlement stipulation is just and reasonable in result, supported by recorded evidence and in the public interest. The division respectfully requests that the commission approve the settlement stipulation as filed to extend natural gas services to Genola. That concludes my summary.
Thank you. Mr. McIntosh is available for cross-examination questions and questions from the hearing officer.
Thank you very much. Dominion, any questions for this witness?
Yeah, just a couple. Mr. McIntosh, you were in the hearing room when Mr. Summers was being questioned by the commission hearing officer, were you not?
I was.
And does the division have an opinion about how these permits should be filed, whether they should be filed at the end in one tranche or whether they should be filed on a rolling basis as received?
I don't, to the division, I don't think it doesn't matter either way.
Okay, thank you.
Yep.
I don't have any further questions.
Thank you. I took one off my list. Mr. McIntosh, I do have one follow-up question, though, with respect to paragraph 10.
Yeah.
What is the division, speaking for the division, what is the division's understanding of what it means in paragraph 10 for Dominion to work with Genola?
From my understanding, it means that the company, Dominion, would work with the city of Genola to make sure that the proper steps are taken to make sure that the conversion to natural gas is done in a safe and correct way.
Okay.
That's my understanding.
And you were in here when you heard Mr. Summers testify about questions I had on that paragraph, correct?
Correct.
Okay. Was there anything that you heard Mr. Summers testify about that the division disagrees with?
No.
Okay, thank you.
Mhm.
I don't really have any other questions, but while you're on the stand, the stipulation, the joint motion earlier, I don't think it included the actual settlement stipulation, did it?
I may not have included the actual settlement stipulation. I may have referred only to exhibits. I would amend that motion to include the application and the settlement stipulation as well.
Okay, and that was a joint motion. Do you still join that motion, Mr. Schmidt?
Yes.
Okay, that motion as amended is granted.
Thank you.
I have nothing further for you.
All right.
Thank you, sir.
Thank you.
Okay, well, that's everyone's witnesses. That's all my questions. Everybody else's questions. I think we're finished. Thank you very much for your preparation today and your appearance today. It's my understanding, does everybody agree that the statutory deadline on this is March 6th?
Subject to check. For whatever reason, I was thinking March 8th, but
Okay,
thereabouts.
could be a G,
I'd have to count the days.
like a G. Okay, somewhere in early March. Okay, so we're aware of the statutory deadline. I just wanted to let you know, and hopefully we will get this discussed and issued before that. Is there anything else from anybody?
No.
Okay, then we are adjourned. Thank you very much.
Thank you.
Thank you.